everyone, welcome to Thorough Newspaper Analysis. This is a video for the 18th of May 2024. Now let's quickly proceed and have a look at the pointers of discussion for today. So the first segment that we have for today's discussion is the editorial segment. And here we discuss an Indian Express article. Now the title of this article is, Should Medical Professionals Be Protected from Consumer Court Proceedings? Supreme Court to Reconsider 1995 Ruling. Now, see, please understand, this is the second article on this topic. Yesterday also, we covered this particular decision of the Supreme Court. So I'll give you a context to it later once we start with the article. Secondly, we talk about the news updates for the day. And this is going to be followed by the last segment of legal news. So let's quickly start with the article. The title of the same is, Should Medical Professionals Be Protected from Consumer Court Proceedings? Supreme Court to Reconsider its earlier verdict. Now let's understand what has happened. See, on 14th of May, the Supreme Court was considering an appeal against a decision by the National Consumer Dispute Redressal Forum. Now, what did the National Consumer Dispute Redressal Forum say? It essentially say back in 2007 that lawyers who deliver deficient services, they will be covered under the ambit of Consumer Protection Act. But the Supreme Court said that no, this is not the correct ruling. Why? Because the Supreme Court categorically differentiated between first the category of professionals from those who carry business or trade. The court said that professionals often have certain factors which are not within their control. So as a result, they may not get the desired result always for no fault on their part. So therefore, they should not be amenable to Consumer Protection Act. And also, the court said that within professionals as well, lawyers have a very unique position. So, for example, yesterday we saw how there were, arguments by the lawyers against this decision of the National Consumer Forum Commission, saying that lawyers have a very different position within professionals as well, because in the profession of law, you cannot guarantee a particular outcome to your client. So, therefore, if there is, a decision which is not favorable to your client, the client cannot approach the consumer forum every time for that. So also the court yesterday, while we discussed the article, we noticed the court also made an observation with respect to the fact that even doctors, who were made subject to the Consumer Protection Act by virtue of its earlier judgment of 1995, they should not be included within or should not be covered within the ambit of the Consumer Protection Act. And therefore, the court said that this decision of the Supreme Court, it should be reconsidered by a larger bench. Now, in light of this, let's understand the context. So almost 30 years before the Supreme Court, on Tuesday, which is the 14th of May, held that lawyers as professionals could not be subjected to legal proceedings for providing faulty services under the Consumer Protection Act. The Supreme Court has rejected similar argument for those in the medical profession. And this becomes all the more important because we see a lot of cases before the consumer forums pertaining to medical negligence. And often doctors are asked to pay compensation. The hospitals are asked to, pay compensation for negligent services of the doctors. So in the case of Indian Medical Association versus VP Shanta, which is a 1995 verdict, a bench of Justices S.C. Agarwal, Kuldeep Singh, and Justice B.L. Hansaria, they ruled that medical professionals, they provide a service as defined in the older Consumer Protection Act. And therefore, they could be sued in consumer court for providing faulty services. After Tuesday's ruling, this decision has now been referred to a larger bench for reconsideration. And the ground for which this reconsideration is sought by the Supreme Court is that we've already discussed that, professionals can be differentiated from those who are engaged in carrying out any business or trade, because professionals occupy a very unique position. No matter how skilled they are, there might always be situations which are out of their control, and therefore they may not be in a position to deliver the desired service. Now let's see what was the 1994 ruling about. So in 1995. Back in 1995, the court acknowledged that professional occupations like doctors, they are often skilled work that require mental rather than manual effort. and differ from other occupations as success often depends on factors beyond the professionals or the professional man's control. Senior advocate Harish Shalve, representing the Indian Medical Council, argued that a medical practitioner cannot be judged based on fixed norms or standards and thus cannot be covered under the definition of services or therefore cannot be sued for deficiency in service under the Consumer Protection Act. However, the court back in 1995 held that a doctor still owes certain duties to their patients, that are duties of care in deciding whether to treat the patient, then to decide what treatment is to be given and how the treatment is to be administered. So if the doctor does not exercise a reasonable degree of care with respect to all of these matters, what is that? Duties of care in dealing whether a particular treatment is to be given to the patient, whether the patient should be treated in the first place. If yes, then what treatment is to be given, how the treatment is to be administered. So all of these factors are to be considered, and a doctor is required to exercise a reasonable degree of care here. The bench of Justices Bela M. Trivedi and Pankaj Mittal in the latest verdict of which we covered yesterday of 2024 appear to be more sympathetic to the notion that medical practitioners as professionals should not be held to the same standard as other occupations. They held that the purpose of the Consumer Protection Act was to protect consumers from unfair trade practices and unethical business practices only, and that the legislature never intended to include professions or the professionals within the purview of the Consumer Protection Act. Now let's understand the complexity, not a bar against consumer protection proceedings. See, legal proceedings under the Consumer Protection Act are heard by the Consumer Redressal Commissions, which are constituted at the district, state, and national level. So we have these consumer dispute redressal forums at 3 layers or tiers. First, we have the district layer, then the second and national level. So under the 1986, which is the older version of the current 2019 law, which was applicable in 1995, the president of each commission would be a person who was or is qualified to be a judge at the district, high court, and Supreme Court, respectively. And the rest of the members, 2 at the district and state level and 4 at the national level, they would be individuals who have the knowledge, experience, or capacity to deal with problems related to economics, law, commerce, accountancy, industry, public affairs, or administration. The petitioners in the older case of 1995, they argued that since there is no requirement for commission members to have knowledge in medical matters, so they are not suited to deal with complex medical issues that would arise in cases dealing with services of medical practitioner. So they back in 1995 argued that if you make medical professionals applicable or fall within the ambit of the Consumer Protection Forum, then you should understand the fact that under the Consumer Protection Forum, the members of the forum, they are not somebody who have a certain knowledge or understanding of the medical profession. So how can they be judge of should the service which is rendered by a doctor be considered as negligent or not, and thereby should he be asked to pay compensation or not? Now, please understand, this was the argument of the petitioners back then, but the court did not find any substance in these arguments, and the court, however, disregarded this concern, holding that requiring members to have knowledge and experience that is specifically relevant to each case, it would lead to impossible situations, such as district commission being able to deal with cases that the state commission would be barred from purely because the former has a member with knowledge and experience that is relevant to the case at hand. So the burden is instead upon the party to provide the necessary evidence and material to allow the members to make an informed decision. So the court said that if we insist upon having a member who's having experience and knowledge in a particular field in order to decide matters which come before the consumer forums, then that would involve a lot of admin difficulties, and it will not be feasible for these consumer forums to decide a range of cases. So therefore, the court said that instead the burden should be on the party that you produce the relevant evidence and aid the commission in understanding your field so as to enable them to make an informed decision whether a deficient service is rendered or not. Even if service is free of charge, medical professionals can still be liable. Let's understand this passage. So the definition of services under the old act and also under the 2019 act, it is expansive, but it explicitly excludes two types of services. Now, what are those? Those that are free of charge and those which are given under a contract of personal service. Now, if you remember, yesterday we saw that court in the current case observed that the services rendered by a lawyer to his client, they are in the nature of personal services and therefore they are not covered by the Consumer Protection Act. Now, regarding medical professionals, the court carved out three types of services back in 1995. First is service given free of charge to everybody. Second is services where everybody pays. And third being services which exempt certain categories of people who cannot afford them from paying. So the first is not a service under the Consumer Protection Act, the court held, and the second is a service. The court, however, focused on the third type of service where certain categories of people are exempted. So by exempting only the services which are provided free of charge in the third category, the court observed that the protection under the Consumer Protection Act, it would only be available to consumers who could afford to pay for medical services, and it is difficult to conceive that this is what the lawmakers intended. Further, this would result in hospitals and doctors giving better medical services to those who could afford it, whereas those who cannot will be, relegated to receiving services of inferior quality. So to avoid this inequity, that those who have the means of paying will be rendered better services, while those who do not have the means of paying will be, rendered inferior service. So in order to avoid this divide or inequity, the court held that hospitals and doctors who fall under the third category, they will fall under the definition of services regardless of whether it is free or not. The court also held that medical care, it is not provided as a contract of personal service, which the court said was present in the case of lawyers in the current case. So the court back in 1995 said that the medical care, it is not provided as a contract of personal service. As such contracts, they are limited to situations where there is an employer-employee or a master-servant relationship between the two parties. Therefore, since there is no relationship of master and servant between the doctor and the patient, the contract between the medical practitioner and his patient cannot be treated as a contract of personal service. So now it'll be interesting for us to see what the Supreme Court, the larger bench of it, will have to say on this matter, whether it, reverses this verdict of 1995. This is going to be a very interesting, update to keep a track of. So now we proceed to the national news category, and this is the first update here. India showcases its green hydrogen potential at the World Hydrogen Summit for the year 2024. The Secretary for Ministry of New and Renewable Energy, Government of India, Shri Bhupendra Singh Bhalla, he addressed the World Hydrogen Summit 2024 in Netherlands, highlighting India's strategic vision and its capabilities in the domain of renewable energy and green hydrogen production. So this was highlighted by the Secretary at this forum and summit. He underscored the comprehensive nature of National Green Hydrogen Mission, comprising components such as pilot projects, there's R&D initiatives that are done, and skill development programs that are run. NASA appoints new chief for artificial intelligence. NASA has given a new role. The new role as the chief of artificial intelligence by NASA, it is conferred on David Salvaginini as the agency's chief or artificial intelligence officer. This is an addition to its current job as his current job as the chief data officer. This is a very important update for the sports enthusiast and for the sports column of your exam section also. Football legend Sunil Chhetri, he announces his retirement. He announced his retirement decision, and he has said that he's going to take his retirement formally from international football on 6th of June. T20 World Cup to stream and broadcast with the sign language and audio description. So in order to make sporting experience very inclusive, on the occasion of Global Accessibility Awareness Day, Disney Star, in association with India Signing Hands, announced the availability of an Indian Sign Language feed for the upcoming ICC Men's T20 World Cup starting 2nd of June. This will be applicable for 10 matches, including the India matches, semi-finals, and the finals. The company will also support an audio descriptive feed along with the ISL feed on Disney Plus, Hotstar, and Star Sports Network. Agni-5 missile stunning striking range. DRDO, which is the Defense Research and Development Organization scientists, they've successfully conducted the maiden, that is for the first time. So the maiden first ever flight test of indigenously developed Agni-5 missile with multiple independently targetable re-entry vehicle technology. The flight test was named Mission Divya Sastra, and it was carried out from Dr. APJ Abdul Kalam Island in Odisha. Now, this is an important update for our fraternity. Kapil Sibal is the president of Supreme Court Bar Association. Senior advocate Kapil Sibal, he has won the election for the president post of the Supreme Court Bar Association. He secured 1,066 votes and defeated his nearest rival and senior advocate Pradeep Rai. Now we talk about an important day for the day, and this is the National Endangered Species Day. The National Endangered Species Day is recognized on the 3rd Friday of May. This year, it fell on the 17th of May, which is yesterday. This day, it is dedicated to raising awareness about the plight of endangered species and the need to take action to protect them. Let's talk about its historical aspects. So National Endangered Species Day, it was established for the purpose of raising awareness about, the plight of endangered species. It was founded back in 2006. The day was created by David Robinson and the Endangered Species Coalition. In the same year, which is 2006, the US Senate passed a resolution designating the 3rd Friday of May every year as this particular day. Also, I would like to plug in an information point here. So if you remember, a couple of weeks back, we did a story on how, the government, there was a matter before the Supreme Court with respect to the conflicting interest of preservation of, let's say, the Great Indian Bustard and the government's need of manufacturing or production of renewable energy. So how could those two be, balanced and harmoniously construed and carried on? So there, with respect to that, the Supreme Court gave certain very pertinent observations. That was a very important case law. Also there, the Supreme Court expressly pronounced that a certain element is a fundamental right. So if you are able to recall that, and it would be absolutely great if you could mention that in the comment section. What was the aspect which was highlighted by the Supreme Court to be expressly a part of Article 21 of the Indian Constitution, a facet of it, and now therefore an expressly declared by the Supreme Court fundamental right. Now this has brought us to the international segment for today. First update is from Chad. Chad's junta leader, General Muhammad Idris Deby Itno. He won African nations May 6 presidential election with 61% of vote. We had already covered this update, and now this is the final verdict. 61% of vote is secured by him, and he has won the presidential post now. Pakistan successfully tests precision-guided Fatah-II rocket. Pakistan did a successful test launch of the Fatah-II guided multi-launch rocket system. The Fatah-II rocket system, it was made to hit the target up to 400 kilometers away with great accuracy. So this is the range of this particular rocket system. Now, with this, we've come to the legal updates for the day. And the first update is from the Honorable Supreme Court. Let's first, at the very outset, mark the name of this particular verdict. It is S. Nitin and others versus the state of Kerala and other. Let's see what is it about. So it pertains to Section 494 of the IPC, Bigamy. Friend or relatives cannot be held to have common intention for offence of bigamy by mere presence in the second marriage. So this is a very relevant and important update. The Supreme Court has held that the charge under the offence of bigamy, which is Section 494 IPC, it can be framed only against the spouse who is entering a second marriage, even during the lifetime of the spouse from the first marriage. So by the mere presence of friends and relatives in the second marriage, it cannot be held that they had the common intention to commit the offence of bigamy unless the complainant prima facie, that is on the face of it, proves the overt act or omission of the accused persons and also establish that such accused, that is to say the friends and the relatives, they were aware about the subsisting first marriage. So what you have to prove? So suppose, let's say, you're a woman and your husband is entering into a second marriage. So therefore, this is an offense of bigamy under Section 494. And your marriage with this accused husband is subsisting. You've not separated. You've not taken divorce. And here you want to implicate or implead his family members, his friends into the offense of, Section 494 for the fact that they were present when the second marriage was contracted. So then what you have to prove is that these persons, they did some overt act or omission and they were aware of the fact that the first marriage was subsisting. Merely the presence at the second marriage is not sufficient to say that they were abettors or that they had common intention for the offense of bigamy. The bench of Justices B.R. Gavai and Sandeep Mehta, while setting aside the criminal proceedings against the relatives and the husbands of the accused wife, observe the following, and I would like to quote it out. A bare approval of the penal provision, it would indicate that the order framing charge is erroneous on the face of the record. Why? Because no person other than the spouse to the second marriage could have been charged for the offence punishable under Section 494 IPC, simpliciter. However, this is a curable defect and the charge can be altered at any stage as per the provisions of Section 216 of the CRPC. So this observation was with respect to the particular matter here, but this is the proposition of law that you can make a note of. Next up is an update from the Honorable High Court of Punjab and Haryana. Failure to fulfill basic financial responsibilities by husband, it amounts to cruelty and desertion. The High Court of Punjab and Haryana ruled. So the Punjab and Haryana High Court has upheld the ex parte dismissal of a divorce plea filed by a husband, observing that the husband failed to fulfill basic financial responsibilities, which amounts to cruelty and desertion. The husband alleged that the wife has left her matrimonial house along with their children, which amounts to cruelty. However, rebutting this particular contention of the husband, the court found that it is the husband who had deserted and committed cruelty by failing to maintain the wife and the children. In this respect, the bench observed that the failure to fulfill basic financial responsibilities contributes to the characterization of cruelty and desertion on part of the husband. Thus, by the common prudence, it can safely be concluded that the appellant husband, by filing the petition for divorce, wanted to take the benefit of his own wrongs. Having himself failed to perform his matrimonial obligations, which is the financial maintainability of his family, the husband, by filing the petition of divorce, wanted to take the benefit of his own wrong. And therefore, having failed to perform his matrimonial obligation, he cannot be allowed to plead that the trial court ought to have granted him divorce because the wife had been prosecuted ex parte. She's been proceeded ex parte. So the name of this case would not be disclosed because it is a matter in the nature of private family dispute, which is a matrimonial sort of a nature. So therefore, the identities of the parties is often protected. So this has brought us to an end of TNA. Thank you so much for watching. Have a wonderful weekend ahead.